Hello there, this is Dominic Jones here from Step Legal Solicitors. We've got a live session, question and answers, medical negligence coming up starting at 12 o'clock. So we're going to hang fire for a couple of minutes, wait for some people to join, and we'll go for it at 12. So bear with us a couple of moments and we'll see if anybody else is going to be joining. Hello, if you just joined us, this is Dominic Jones at Step Legal Solicitors. We've got our 1 hour medical negligence question and answer session coming up. Just hanging on for a couple of minutes so that we can start at 12. We'll see if anybody else is going to be joining us in the meantime. So just hang on for a couple of minutes. Hi there, this is Dominic Jones at Step Legal Solicitors. We've got our 1 hour medical negligence question and answer session coming up in about 1 minute. We're just going to hang fire, see if anybody else joins us before we start at 12 o'clock. So please sit tight for another moment. Okay, 12 o'clock. Welcome everybody who's here to join us. I'm Dominic Jones, the Head of Medical Negligence at Step Legal Solicitors, based in Crewe, and we deal with cases all across the country. I've been working in the legal profession for 17 years now, 13 years as a solicitor, focusing on personal injury and now medical negligence, Been working at Step Legal Solicitors for just over 3 years. Came here in July 2020 and opened up a new department that is now doing very well. Prior to that, I've worked at other firms in the Northwest doing medical negligence and personal injury. I was appointed as a Deputy District Judge in 2022, but my work as a judge doesn't relate to medical negligence, so anything today is just in connection with me working as a solicitor doing medical negligence. So this is a question and answer session. I've prepared a list of 20 questions that I'm going to go through, which I think, based on my experience, are the main questions that people want to ask at the beginning when we're looking at taking a case on, and also as a case progresses. If anybody's got any questions during the session, please ask a question, and hopefully I'll get around to answering them. If there's any questions that I haven't managed to get around to answering during the session, then I'll see if I can get them answered for you this afternoon. Okay, so question one, what is medical negligence? Right, that's the obvious question. Negligence is a legal concept where a person or an organisation has made a mistake that's more than a mistake that's allowable, the kind of a mistake that shouldn't happen. Humans, they make mistakes. Doctors and nurses, they're humans, they make mistakes, they're allowed to make some mistakes, but where it becomes negligence is where they've made a mistake that they shouldn't make. It's ones where other doctors and nurses in the same circumstances wouldn't have done what happened. So there's no real valid defence for what happened. Following the mistake, in order for there to be grounds for a claim, it's got to have resulted in the patient suffering an avoidable level of harm. So it's either caused an injury that wasn't there before, or the patient is in hospital or at the doctor's with a condition, and because of the negligence, it then becomes worse. So there's got to be two key issues in a medical negligence case: the event, the act, the thing that the doctor or the nurse has done, which is a mistake that they shouldn't have made, accompanied by harm, avoidable harm that shouldn't have happened, but it did happen because of the mistake. Okay. Question two, what types of situation typically lead to medical negligence claims? Okay, well, in my career, the main problems that lead to medical negligence claims are situations with GPs, and quite often situations in the A&E departments at hospital. So A&E cases, you've had an accident or it's a medical emergency, you go to hospital, hopefully they're going to find out what the problem is and get it fixed up for you. A&E departments are usually very busy, the doctors are under a lot of pressure. Sometimes what happens though is that they misunderstand the symptoms or they miss something. This can then lead to a diagnosis, misdiagnosis, and then you end up being on the wrong treatment path, or the original problem doesn't get diagnosed or treated. I've had cases in the past where a person called for an ambulance. She was suffering with symptoms of a heart attack, basically, and they seemed quite straightforward symptoms of a heart attack, but the A&E crew, the ambulance crew and then the A&E crew treated it as indigestion. So she was taken into hospital, put on a bed in the A&E department, and they thought she had indigestion, and a few minutes later her heart stopped beating. She had a cardiac arrest, and the team had to come in with all the equipment that you see on in the movies, with the resuscitation and the electric shocks and everything. And unfortunately she survived, but that was a good example of where they'd completely misunderstood the symptoms, didn't give her the right treatment, and then she ended up with a cardiac arrest. Another case I had was a young chap had a night out, had a couple of drinks, but unfortunately he was then assaulted, bashed his head in on the curb when he fell down, was taken to hospital, and his symptoms that were consistent with brain trauma, including not really knowing where he was, slurring his speech, acting a little bit intoxicated, the A&E doctors treated as intoxication. They just thought he was drunk. They didn't seem to pick up on the fact that he'd been assaulted and smacked his head in on the ground. Turned out he had bleeding on the brain, which worked out okay for him in the end, but again, another misdiagnosis there. GP negligence. The GPs are usually the sort of gateway to the NHS. If you've got an emergency, you can go straight to A&E, but otherwise you can't take yourself off the hospital and see any old consultant that you want. If you've got a leg problem, you can't rock up at the hospital and say, I want to see an orthopaedic doctor or anything like that. Basically, you've got to go to your GP. So go to your GP, say to your doctor, I've got this problem, it's an ache, it's a lump, I get palpitations, whatever it might be, I get bleeding from somewhere that shouldn't be bleeding. You're then relying on the doctor recognising what those symptoms might be and determining whether it's nothing to worry about or whether it's something that needs to be investigated. And if it is something that needs to be investigated, you're relying on your doctor sending you off on a referral up to the hospital to see the right team. Sometimes the doctors misunderstand what the symptoms are. They may not send you to the hospital. They may tell you everything's okay and it's not. They may make a hospital referral, but it's on the wrong urgency level. For instance, if you've got, let's say you've got cancer, you've got the early stage symptoms, the GP misses what the symptoms might be, and they might refer you, but it might not be a cancer referral. Then you get stuck in the long waiting list to see somebody. Meanwhile, things are getting worse. So those are a few examples of common areas of medical negligence. It's usually doctors not picking up on the symptoms. If they don't understand what the symptoms mean or they misunderstand them, you can end up with the wrong diagnosis. You can then go down the wrong path. You're not getting the right treatment. The real problem isn't treated, and then it can get worse. I think we've got a question just come up here, so let's just have a look. Okay, family member was misdiagnosed and as a result didn't receive the right treatment. They've since they've since had to leave their job because they didn't get early treatment. Is this something that I can seek legal help for? Absolutely. So this fits in quite well with what I was just saying about misdiagnosis and then not getting the right treatment for the actual problem. Things then get worse, and it appears this person has ended up having to leave their job, presumably because they weren't fit enough to go and do the job anymore because of the medical condition. Yes, absolutely. The claim seems to be quite valid there if it can be proven that there was a misdiagnosis and that it's caused avoidable harm and that it's caused this person to lose their job. It would be a loss of earnings claim. We would be able to look at what that person's earnings were before they had to leave the job and project that forward to work out what they've lost already and what the likely loss is going to be in the future, and that would form part of the claim for financial losses that is added on to the claim for physical injuries. So hope that answers your question. And obviously if you wanted to get in touch for some more detailed advice about that or in connection with bringing the claim, then obviously please do get in touch. What happens if the medical negligence led to the loss of a loved one? Okay, this is something that unfortunately happens quite a lot. I would say that in my career doing medical negligence, usually at least a quarter of my cases are being brought by family members in relation to a loved one that they've lost as a result of usually delayed treatments. They usually relate to cancer cases. They usually relate to the person went to their GP, they've got symptoms, not very nice symptoms, and they didn't get the referral on time. They've then gone back to the GP at a later date because the symptoms are still there. Maybe in the meantime the GP has prescribed them some medication, which obviously isn't going to work because it doesn't treat cancer, but it's prescribed because the doctor has misdiagnosed what the original problem is. They go back to the doctor later on, then they eventually do get the referral because the symptoms are then more pronounced. But in the meantime, what's been happening is the cancer has been getting worse and worse and worse. And sometimes you end up with a diagnosis at a stage where it just can't be treated anymore, and or successfully treated. The person may receive some chemotherapy or radiotherapy, but in the long run, it's too late to really successfully deal with the cancer, and they then pass away. The claim would need to be brought usually by the person's next of kin, or if the person left a will, whoever it is who has been appointed as the executor of the deceased person's estate. The claims brought on behalf of the estate and will include any avoidable pain and suffering that the person has gone through that could have been avoided if they've got the right treatment on time. If the person is married, then there will be a statutory bereavement award for the spouse or civil partner, which is it's set by statute. It's about £15,000. Obviously, it doesn't bring back the loved one or really compensate for the loss of the loved one, but it's just something that the government one day decided they were going to bring in as some kind of token fixed sum. The costs of any funeral can also be included, and also if there's any financial dependents, then they're entitled to bring a claim if they were financially dependent on the person who has passed away. For instance, if there's an elderly couple and there's a loss of the person's pension into the household, or if there's a married couple, they were both working and there's a loss of income into the household. So all those issues can be claimed for. Linked to that, what if my child has been a victim of medical negligence? Same sort of thing. Obviously, if the child is deceased, then a claim can be brought in the same way. If the child is still alive, a claim can be brought on behalf of the child. All the same principles apply. Was there a breach of duty? Has there been avoidable harm? Obviously, just bear with me. One moment, no, that's fine. The child is obviously not old enough to bring a claim on their own. They can't sign a contract with a solicitor. They don't have the legal capacity to bring a claim. So somebody needs to step into the child's position as the client to sign the agreement with the solicitor, bring the claim, make the decisions. Sorry about that. Just checking on the message there. It's usually a parent. So the parent would usually step into the shoes of the child, become the client, sign all the documents, make the key decisions on the advice of the solicitor. At the end of the case, there would need to be a court hearing where a proposed settlement for compensation is then approved or not approved by a judge, and the compensation then needs to be invested on behalf of the child until they're 18. Usually the compensation will go into the court funds account where they'll earn interest. Alternatively though, if the parents can find a good quality savings account for the child where it's going to be earning interest, and the funds can't be accessed until they're 18, then it may well be invested there. An application can be made from time to time to withdraw some money from the compensation fund on behalf of the child, if the need for the money is something that's going to be of genuine benefit to the child. And those sorts of situations are assessed on a case-by-case basis. Question 6. What if my medical negligence claim involves a cosmetic procedure or plastic surgery? Absolutely fine. No problem with those kind of claims. Claims can be brought against the GPs, NHS, private hospitals and private doctors as well. If it's in the medical setting and there's negligence, you can have a medical negligence claim. There isn't really much difference in pursuing a private hospital. The claim is investigated usually by an insurance company rather than the NHS, but overall there shouldn't be any problems with that. So if you've had any cosmetic treatment and it's gone wrong, then get in contact with us about a possible case. The slight difference that you get between normal medical negligence and cosmetic treatment claims is usually in medical negligence the situation is that the person already has a medical problem for which they need help. That's why they've gone to the GP, they've gone to the hospital. Usually in cosmetic procedures, it's usually a cosmetic issue. Somebody isn't happy with something about their body, fair enough. You want to get it treated, absolutely fair enough. So sometimes you'll get situations where the person isn't happy with the outcome. That doesn't necessarily give rise to a legal claim. If you're not happy with the outcome, it just might not meet your expectations as to what you thought it was going to be beforehand. The only way you could turn it into a medical negligence claim is if the outcome is not as you expected, or if something's gone drastically wrong, and the reason for it is the surgeon has done something wrong. So if the surgeon's done everything right, you just don't like the outcome, you probably won't have a case. If the surgeon's done something wrong in the procedure, it's gone wrong, surgical error, cut the wrong thing, stitches went wrong, you might have had an infection after the procedure that didn't get treated right, that's when it might turn into a claim. Got another question popped up here. What about tattoos? Tattoos, it's not really something I've really had many inquiries about over the years. It's not really a medical procedure, so it wouldn't be covered by the usual law relating to medical negligence. If something's gone drastically wrong that has resulted in maybe an infection, then it might be something that would want to be looked into as to how it ended up with the bad result. If you, again, similar to the cosmetic surgery situations, if you go for a tattoo and the tattooist does a bad job, and you're not happy with it, it's going to be tricky to bring a claim there. But if something has gone wrong that's resulted in a medical problem, in fact, I remember a few years ago we had a case, or a colleague of mine had a case where they'd ended up with a very nasty infection following the tattoo, and they'd apparently followed the usual advice following a tattoo about how to treat it and keep it clean. So there was a concern there that something had gone on, maybe with the needle being used, maybe it wasn't clean, and I'm not entirely sure what happened in the end of that case. It was a colleague's case of mine, and I think it may have moved over to a different firm at the time. But on the whole, though, it's not usually something that crops up as being the usual type of situation that leads to a claim. Next question: how do I know if I've got a medical negligence case? Right. Well, the first well, before you speak to a lawyer who will tell you if you've got a medical negligence case, the first inkling that you'll get is usually when you're suspicious about your condition. So let's say you've got a problem and you go to your GP, whatever the problem might be, and the GP says, oh, it's nothing to worry about, I think it's this, here's some antibiotics, I'm sure it will clear up. If it doesn't clear up, then you might be thinking, has that doctor got it right? You might be a bit suspicious. Okay, maybe something a bit more serious. Maybe it's cancer. Maybe you've gone to your GP. They tell you it's all going to be okay. Whatever the symptom is, might be a lump, bleeding, whatever it might be with the cancer, headaches maybe. GP says, oh, you're going to be okay, I think it's nothing to worry about. And then the symptom doesn't go away, it gets worse. Then you might be thinking, I wonder if the doctor's got this right or wrong. In a surgical setting, you've gone into hospital, you've had an operation for something. Before the operation, you've had a good chat with your consultant, you understand what the procedure is all about, you understand how long it's going to take for you to get back on your feet, but it doesn't go according to plan. You might have a prolonged recovery, you might have other suspicions that it just hasn't ended up how you thought. I can give you loads of detailed examples of that, but I think for these purposes today, those sorts of situations are what might make you think, I should speak to a solicitor here. So it's usually something's gone on in your care, your treatment, you haven't got better as you expected. You might think, okay, I think something's gone wrong here. Alternatively, of course, a doctor might come out and say to you, I'm really sorry, but something went wrong during the procedure. Or it might be, eventually your doctor does refer you to hospital, and then you get a diagnosis, and then you go, right, well, now we know that back then the doctor was wrong. Then you get on the phone to a solicitor, tell them what's happened, and then the solicitor will be able to get all the right information from you and tell you if you've got a case or not. If you have got a case, they'll want to take it on. They'll talk to you about the funding, no win, no fee, and that sort of thing, which I'm actually going to come to shortly. And then you go for it. And what happens next, I'm going to come to shortly. Got another question. Here we are. Let's have a look. What happens when somebody dies from a mistake, and how much do they get? Okay, I think we touched on this earlier on. So what the situation is if the person has been through a bit of a tough time, pain, suffering, and then died, a value will be worked out for that by reference to what those symptoms are. It's difficult to say exactly how much that would be because each case is assessed on a case-by-case basis. Again, funeral costs, financial dependency claim, if the person was in a position where they had earnings from a job or a pension, and the loss of that income to the household creates a situation where those losses can be calculated and included in the claim. And also the bereavement award, the statutory figure, £15,000 pretty much, for the spouse or civil partner. Okay, how do no-win, no-fee arrangements work for medical negligence cases? Right, what I always say to my clients is no-win, no-fee means if the case doesn't win, the solicitor doesn't get paid and the client doesn't have to pay anything. If the solicitor doesn't get paid, obviously if they've been running the case, they're going to be making a loss of time. Time is money. They make no money on the case, it's a loss. So first of all, what a solicitor's going to be wanting to consider when they're speaking to the client at the early stage or the first appointment is, does this, using my experience, does this sound like a situation where there might have been negligence and avoidable harm? Does this sound like the sort of claim where I think we could bring it and it's got a reasonable chance of winning. If so, the reasonable chance of winning means there's a reasonable chance of getting paid on it. If we think that there probably wasn't negligence, there probably wasn't avoidable harm, the case might have other issues where we think it's probably not going to win, then the solicitor probably isn't going to take it on, because it would mean it won't win, or probably won't win, in which case it's a loss, and it's also taking time away from cases that that are going to win and that do need to be progressed on behalf of other clients. So there'll be the assessment of the prospects. If the case is one where the solicitor wants to take it on, it'll be on a no-win, no-fee basis. That means if the case is run and it doesn't win for whatever reason, maybe the evidence isn't quite strong enough, or something else happens in the case and it needs to be closed, that's it, no bill. There shouldn't be a bill for the client, as long as they've complied with their part of the agreement, which is, it's really easy, to be honest. It's just cooperate with the claim. If we need information, give it to us. If we needed to go to a medical appointment, turn up. I've never actually had a situation where we've had to send a bill to a client. If you wanted to bring the claim in the first place, obviously you're going to cooperate. If the case does win, though, then compensation will be awarded, and the solicitor will be entitled to payment of their fees. The fees come from two places. First of all, a bill will be sent to the defendant. The bill will be based on the amount of work done, which will have a monetary value. The bill will also include the costs that have been incurred in relation to obtaining medical reports, court fees, and so on and so forth. The solicitor is also entitled to charge a success fee to the client, which would then come from the compensation. It's also based on the amount of work that's been done, but it can't exceed 25% of the compensation figure for injuries and past losses. It doesn't apply to future losses, so if part of the claim includes future treatment costs or future loss of earnings, the success fee doesn't apply to that. So that's how the solicitor will get paid. It's a combination of the success fee and what can be recovered from the defendant at the billing stage. Another cost is what's called legal expenses insurance. So when we instruct medical experts, they prepare a report. The bills are usually quite substantial. You probably can't get a medical report in a medical negligence case for less than around £2,000. So usually it's £3,000 to £4,000. Sometimes it can be more than £5,000. You usually need more than one report in a case. Sometimes there's 4 reports. In a really complex case, you might have even more reports. If the case wins, the defendant's going to have to be paying for those invoices. They go in your bill. If the case doesn't win, though, then technically the responsibility for paying the invoices is the client's, but the legal expenses insurance will then kick in. And like any insurance, a claim we would make on behalf of the client to the insurance company: this is a case we've had, it's not succeeded, we've incurred these disbursements, the insurance is in place, and we now need the insurance company to pay up and discharge those disbursements. So the client wouldn't have to pay for them. So if the case doesn't win, they're not paying the solicitor's fees, they're not paying for the disbursements. If the case does win, the client will be paying the success fee and also the premium for the insurance policy, which is usually it's on a sliding scale. Usually a few £100, can be more. If the case is worth a lot, then the insurance might be a few £1,000s as well, but it's usually not a great deal, not a great proportion of the damages anyway. And obviously you can't really proceed very far with a medical negligence case without the insurance. Otherwise the client is then going to be facing the potential of having to pay off those experts' reports and court fees themselves if the case doesn't win. But the long and short of it, though, is usually, you can bring the case. If it doesn't win, you don't pay anything. Is the long and short of it. Next question. What if I signed a consent form before a medical procedure? Does that impact my ability to make a claim? Okay, this is an interesting one. If you're having a medical procedure or operation, then what should happen beforehand is you should be given all the information to enable you to make an informed choice about whether or not you want the procedure. And the information should include what happens if you don't have the procedure. So obviously the fact that the procedure is being talked about means that you probably need it, but you don't have to have it if you don't want. So what happens if you don't go ahead with the procedure? The likely benefits of the procedure. So this is why they're doing it. They're going to be doing this procedure to fix a broken bone or remove a cancer or whatever. But the most important information they should be giving you is the frequently occurring risks, what can go wrong during the procedure, so that you can then balance up the benefit of having the operation and it working, hopefully, versus what might go wrong during the procedure. And common things that you'll see on consent forms are infections. Obviously, if they're opening you up, there's a risk that you could get an infection. Usually what they'll do is they'll give you a load of antibiotics before, during and after that should take care of anything like that. Damage to adjacent tissues. Now this is a situation that you often get in medical negligence cases where obviously if they're opening you up with a scalpel, they then need to get through skin layers, muscle layers, fat layers. They need to get at the organ or whatever it is they're going to be doing the operation on. Everything sort of underneath your skin is fairly tightly packed in. Organs sit right next to each other. They're surrounded by nerves, they're surrounded by blood vessels. So whatever the target of the operation is, it's always adjacent to other tissues. So there's a risk of damage to adjacent tissues. Sometimes they might get nicked. A vein might get nicked, there might be bleeding. A nerve might get nicked, which might lead to more serious neurological problems. Bleeding, that can be a problem, but usually they can deal with it straight away because they see it happening straight away. Those are the main sort of issues you have with surgical situations. So let's say something goes wrong and there is damage to an adjacent tissue. You come out, turns out you've got a bit of a problem. Maybe something won't work properly because a nerve has been nicked. You should get told about it. If you don't get told about it because maybe the surgeon didn't notice, you'll probably soon find out that there's something wrong when whatever it is isn't working properly. But you signed a consent form that said you consent to that risk. Right. It doesn't mean you consented to negligence. I've won cases like this in the past. It all depends on how the incident occurred, what the incident was, what was the damage, what was the tissue that was damaged. If a doctor has had a genuine accident during very difficult surgery, then it's probably not going to be negligence. But one of the cases I won, a chap was he'd hurt his shoulder. I think he had ligament damage in his shoulder following, I think he fell off his bike. He needed an operation to fix this ligament in his shoulder. And during the procedure, the surgeon, instead of cutting the ligament, cut a major nerve in his shoulder that partially paralysed his arm and hand. Now, damage to adjacent tissues was on the consent form, but he didn't consent to damage to adjacent tissues caused by negligence. So we were able to prove that it was a negligent incident, not a genuine accident, and he went on to win that case. I think we had another question here. Let's have a look. Okay, if I have an emergency medical procedure due to an accident and I don't agree with the outcome, hold on. For instance, an amputated limb that may have been saved, can someone still make a claim? Okay, I'd say if you got a situation where you have an emergency treatment and you ended up with an outcome that you don't like, for instance, an amputated limb, a solicitor's probably going to take the case on, get your medical records, and have a good look at what actually happened. If you're in an emergency situation, then the A&E doctors are basically they're not going to be doing anything to you that they don't think is necessary. You may not be in a position to consent, but there's a general sort of implied consent that if you're lying on a trolley in A&E with serious injuries, that you are giving your consent for the A&E doctors to probably do what it takes to save you. They probably wouldn't amputate in an emergency unless it was a real emergency and whatever it was, the leg or the arm, had to come off. If they could save it, they probably would. Other treatments, though, if you sort of wake up, you've been in hospital a couple of weeks, you can't remember what happened, but you'd had an accident a couple of weeks previously, doctors have treated you, you've got a problem that you're not happy with, you're probably going to have some troubles with a claim there, but it should be investigated. I think I had a case a few years ago where a client had been in a very serious RTA and had multiple fractures, multiple soft tissue damage, and the hospital had treated all these injuries and done a fantastic job, but it turns out that they'd done something wrong. This is a few years ago, so I can't remember all the details. They'd done something wrong with his wrist, and he couldn't get his wrist or his hand to work properly anymore. And I think in the end I had a chat with the client, and he decided to withdraw his claim because he sort of realised that these guys had saved his life and had fixed up all manner of problems that he had with his body, and then he decided that maybe it wasn't the best thing to do to try and sue them, where they'd saved his life, fixed him up, but got one thing wrong. He did have a problem with his wrist, but he decided to withdraw that claim. But yeah, generally, if you have an emergency treatment, it makes the situation more complex from the legal perspective. Just bear with me. Okay. Right. Where are we? Can I pursue a medical negligence claim against both private and NHS healthcare providers? Yes. I mentioned that earlier. It doesn't really make much difference. Doesn't make much difference to me anyway. It would be investigated by a different organisation, but overall the legal principles, the medical principles, is absolutely the same. Doesn't make any difference. That's absolutely fine. How long do I have to file a medical negligence claim after the incident? Right. Well, technically you have 3 years to issue court proceedings. Otherwise you run out of time. And then, I mean, technically you could issue court proceedings after then, but you'd then have to persuade a judge that the out-of-time claim should be allowed in. So you'd have to have a very good reason for not issuing proceedings within the 3 years. But the big question is, when does the 3 years start? Right. It begins or starts to count from when you have sufficient knowledge or suspicion that you might have suffered some harm, as a result of possible negligence, and you ought to start investigating it and asking questions. So if you have an operation, the surgeon makes an error and they tell you straight away, you know about it straight away. Often what happens though is you don't know about the negligence at the time. You don't know about it until months later, sometimes years later. The usual situation is you go to your doctor or you go to hospital, there's a misdiagnosis, you go away because you've been told everything is all right and you think everything's fine. You know, that pain, that'll get better. You know, okay, well, I'll give it a few weeks and it'll get better. Maybe you've got a fracture in your foot and the doctor says it's just soft tissue. It's going to be sore because you had an accident, but give it a couple of weeks and you'll be fine. In the meantime, so you think you're fine. You don't know there's been any negligence. Turns out you don't get better. Turns out that actually you had a fracture in your foot that's then healed at a peculiar angle. It's when you find out, that's when the 3 years starts to count. But as soon as you find out, get in touch with the solicitor, get the claim up and running, because the deadline for getting court proceedings issued at the end of the 3-year period, you're not going to find a solicitor who's just going to issue proceedings like that. A lot of work goes into getting a case to the stage where court proceedings are ready to be issued. Medical records have got to be requested and obtained. That can take weeks and sometimes months just to get the records. Then they've got to be gone through, reviewed. Is the evidence strong enough? If it is, right, let's get an expert on board. It can take months to get a report from an expert. When you're ready to submit the claim, you submit the claim. The defendant then gets 4 months to investigate the claim. So the process before you're even ready to issue proceedings takes a while. So if you contact a solicitor with, let's say you've got less than 12 months left, you'll probably find that some solicitors might take it on and some might just say, no, we haven't got enough time. If you leave it to 6 months, you're probably not going to find many solicitors that would take it on. And if you leave it, I mean, I've had people phone up and limitation is that's the term, the legal term, limited. The period is limited, so the limitation date. 2 weeks, sometimes less than 2 weeks, and you have to say, oh, I'm very sorry, we can't take that case on. There's just not enough time, and obviously at the same time you have your other clients who are waiting patiently for you to work their case through, and taking on a case with such short time left would mean that you're basically going to have to get your other clients to hold on while you focus all your attentions on this new case. It's just not fair. So yeah, usually as soon as you get an inkling that you think there might be a case, get on the phone to a solicitor, me ideally, and get some advice, see if there's a case, and if so, it will be taken on. Can a medical negligence claim be pursued if the healthcare provider denies any wrongdoing? Guess what? They nearly always deny wrongdoing. I'm sure that won't come as a surprise. Often a person will bring a complaint because of the treatment they've received. Usually the outcome of the complaint is that some failings have been found, lessons have been learned, but overall no harm was caused. Usually those kinds of complaint responses end up with successful medical negligence claims. So even if you've had a complaint response where they say they haven't done anything wrong, you should still get legal advice on it. When the claim is eventually submitted, guess what? They usually deny any negligence. By the time the claim is submitted, we will have our own experts on board who've looked at the situation. They think there's negligence and avoidable harm. The claim goes in, the defendant will then get their own experts on board who will then look at what we've said. They invariably say there wasn't any negligence or harm caused. That's when you have to go back to your own experts, and then you say, right, their guys say this, what's your position? it would be quite rare that our own experts would then actually change their mind. Usually they're good experts, they stick to their guns, and then we stick to our guns, and the case goes on. And usually the case ends up being settled in our favour. So a denial of any wrongdoing at the complaint stage, or a denial in the response to the claim can still be brought. If they've actually got a really good defence, then maybe we close the case. But they'd have to have a really good defence. Okay, then we've got another question here. Let's have a look. What could you do if a patient is alleging negligence against me? Right. I couldn't do anything because I only do claimant work. I work for clients pursuing the claim. If you're a medical practitioner, then you should have insurance. There'll be a professional body, insurance company who insures your work, so that in the event that anything goes wrong, the insurance will kick in. That's a situation for GPs and private practitioners. If you're working in the NHS, usually the first you will find about, or the first you'll know about a medical negligence claim being brought is somebody in management at the trust or in the legal department will contact you to say one of your old patients is bringing a claim, because claims against the NHS are brought against the trust. Hospitals, they're brought against the trust that runs the hospital. Claims against GPs or private practitioners, they're brought against the person. So if you're in private practice, you're a person, the claim is brought against you, contact your insurance company. If you are working in the NHS, there's a whole system set up to assist you with the claim. You'll have to cooperate with it, but I'd imagine that things are already in place to deal with that situation for you. Okay, next question. How does the process of pursuing a medical negligence claim typically unfold? Okay, client gets in touch, case is taken on, medical records obtained, which can take weeks, months. We then go through each of all the sets of medical records. If you've been in hospital, we'll get your records from the hospital and your GP. You might have had treatment at one hospital, then another hospital. We'll get all your medical records, basically. We'll go through them, we'll find the relevant stuff. That then becomes evidence in your case. We will extract the relevant entries from each record and put them in one document that we call a chronology, so that when the chronology is finished, we can then see what was happening, where, in chronological order, who did what and when, what was known by whom and when, and then we're able to form a much better picture of what happened and whether there might have been negligence. If we think there was, that's when we contact experts. If we think a GP has been negligent, we'll need a GP expert. If a cardiologist has been negligent, we'll need a cardiologist. If an A&E doctor has been negligent, we'll need an A&E doctor. If it relates to your leg, we need an orthopedic expert. So we match up the experts to the relevant specialisms, contact them, put the information to them, and see what they reckon. Do you think there might be a case here? See what they say, and if they come back and say, yeah, actually, I think this case has got something, then we would then get the legal expenses insurance. We would then formally instruct those experts. So that's when it's a formal letter of instruction. They then prepare a formal report. This is what happened. This is where the failings were. This is the harm done. When we've got that, claim gets submitted to the trust. They investigate. They've got a 4-month investigation period. You rarely get the response in 4 months. It usually goes on a bit. then when you get the response, that's when you have a bit of a stock take, really. Our evidence says this, they're saying that. Have we still got a case or not? If they admit anything, then we'll be looking at settling the claim. If they deny anything, we go back to the experts. Have we still got a case? Have they got a good defence or not? During the period where they are investigating the claim, we'll usually be gathering up evidence that will help us work out how much the case is worth, so that by the time we get the formal response, we're then able to make an offer of settlement, which they may take, they may not take, we might negotiate, but then hopefully the case is going to get wrapped up. If the case goes on, in theory you could end up in court, but that's really rare. It's really rare for a medical negligence case to actually go all the way to trial. They are usually the cases where they're worth an awful lot of money, so there's a lot at stake, and the medical issues are complex. If the medical issues are straightforward, it'll be wrapped up earlier, and if the value of the case is more modest, it'll probably be wrapped up earlier, because neither party wants to go to court and lose and end up with a big bill to pay. So it's usually the cases, high value, complex medical issues. There aren't that many of those cases, so usually you don't have to worry about going anywhere near court. That's how they usually unfold. It can take a bit of time, unfortunately. Each stage can take ages. You're waiting for the medical reports, you're waiting for your medical expert, you're waiting for the other side to come back with their response. They all add time on. Most cases, probably 18 months to 3 years to settle. Some of the really complex cases can take longer. If you've got a really straightforward case, we try and get it wrapped up pretty quickly. But most cases, 18 months to 3 years. I think we've got another couple of questions here. Let's have a look. Have you ever had a very unusual case? No, probably I wouldn't describe them as unusual. I've had all sorts of different cases. They all seem a bit unsurprising to me now. Quite often something's happened and a person phones me up to talk about it, and I'll say, well, I've dealt with a case like that before. Often people, if you don't have anybody who's having any medical treatment, and you're not used to having medical treatment, and you don't work in the medical negligence sector, generally what you hear about is the NHS doing a good job, and generally they do a good job. You might pick up about some stories in the news, things have gone wrong, but yeah, most cases, they're not unusual to me. Missed fractures, missed symptoms, non-referrals, misdiagnoses. Think of a part of your body. I've had a case that relates to it from head to toe. Yeah, it's very interesting work as well, and you'll learn a lot about medical stuff, anatomy, how parts of the body works, what happens if one thing stops working, how does it affect another part, and the more experience that you have in the field, the more medical knowledge you have, and that then helps you on subsequent cases, because when somebody might phone up that they've got a potential case that relates to something, you have a medical understanding, obviously not as much as a doctor, but a fairly good medical understanding of what might have been going on at the time. Okay, I think we had another new comment there. Let me just check. Okay, if the case goes on for a long period of time and the medical issues get worse during that time, can this affect the outcome and the compensation? Absolutely, yeah. Basically, whatever the outcome, if it can be linked to the negligence, it's coming in the claim. And what we would also do before we settle the claim is we would get unless it's a really straightforward thing and you've already fixed and cured. Otherwise, we get a medical expert to consider what are the long-term complications or implications, what might go wrong in the future. Is there likely to be a deterioration? If so, what? Are there any risks of developing other problems? And we would then factor that into the value of the claim. So, yeah, anything that we can ascertain is linked to the negligence, that's going to be claimed for. Okay, we've got 5 minutes left. What role does evidence play in supporting a medical negligence claim? Evidence is key. The situation is we are alleging that medical practitioners have not done the job right, basically, and got things wrong. It's a very serious allegation to make. You shouldn't make the allegation unless you've got evidence. And the evidence is other experts in the same specialism, they say it was a mistake. And the medical records obviously back it up. So the medical records got to back it up. You've got to have your experts on board. You shouldn't be making the allegation if you can't back it up. And obviously the NHS or a private insurance company, they don't just roll over and give you compensation because you say you want compensation. You've got to prove it. You've got to have the evidence. You've got to prove what's happened. If you haven't got it, they won't be paying you a penny. So evidence is very important. What is the importance of expert medical testimony? The experts are all important as well. If you go to submit a claim and you say, I mean, if it's really, really, really straightforward, you could try submitting it without expert evidence. But generally, you'll have your expert evidence. If you submitted a claim and you say, on such and such a date, you got this completely wrong because of blah, 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 and I say so, well, you're not going to get anywhere with that either. You've got to be able to say, you got this wrong because of this, and our expert says that it was wrong as well. That's when you're going to start getting somewhere. Evidence, medical expert evidence as well, very important. What damages can be claimed in a medical negligence case? Damages for any injuries that you've suffered that can be linked to the negligence can be claimed for. It's generally the avoidable bit. So generally, you're seeing the doctor or you're in hospital because you've got a medical problem. You've got some kind of injury or condition to begin with. You can't claim for that. You've already got it and it's nothing to do with the negligence. The only bit you can claim for is how that thing has been made worse by the negligence. So maybe they miss a fracture and it takes longer to heal. You've got prolonged level of prolonged period of pain and suffering. Cancer, if they don't get to that at the right time, then obviously the avoidable harm can be very serious. Strokes as well. If you're having a stroke and they don't recognise it and treat it quick enough, you can end up with all sorts of avoidable problems there. But avoidable injuries, that can be claimed for on the other, and including psychological injuries as well. If the incident has caused you to suffer a psychological condition, often you can end up depressed because your health is now poor because of medical treatment. Anxiety, you may not want to go see the doctors again. Sometimes people can end up with post-traumatic stress disorder after medical negligence. So physical avoidable injuries, psychological avoidable injuries, financial losses as well. If you've missed work, somebody's had to care for you, you've had to buy things for your house to help you get around it. Even in the more serious cases, if you've had to buy a new house that's suitable because your old one isn't suitable. Anything that can be linked to a financial loss or expense because of the incident, that can be included in the claim. Is there a limit on the amount of compensation? No limit. If you can prove that the injury or the loss comes from the negligence, it can be included. With the financial losses, I should also add that you can only claim for them if they're reasonably incurred and reasonable in amount. What does reasonable mean? Well, it depends on the case-by-case basis. A person is expected to take reasonable steps to mitigate their loss. If they are injured and they can't go, let's say they're injured and they don't go to work, but they could, they won't be able to claim all the loss earnings if they could have been in work earning, but they've just chosen not to. So they're expected to take reasonable steps to mitigate the losses being incurred. How does the legal process address emotional distress and psychological impact? Just address that. If you've got, if it's just that you're upset about what's happened, then that is generally included in the overall figure that you'll get for your physical injuries. They take into account that it's been upsetting. If you've actually got a psychological injury, that can be included as well. We just need a report from a psychologist or a psychiatrist to say, this is the background to the events, these are the symptoms that the person has had, this is the condition, this is the prognosis. Are there any alternatives to going to court when pursuing a medical negligence claim? Yes, well, pretty much the entire process doesn't involve the court. Cases very rarely go to court, as I've already mentioned. Sometimes cases go into the court process, but you as the claimant wouldn't really notice anything. It's just different work that the solicitor has to do. Is there any alternative to bringing the claim? Not if you want any compensation. You can bring the complaint, but they don't usually produce anything productive. They're certainly not going to give you any compensation on the back of a complaint. The only real way, if you want any compensation, is to bring a claim. So if you've ended up losing your job, you've got bad symptoms, financial losses, the law recognises that there is a value in those and allows a person to bring a claim. That's what the process is there for. And also, the defendants, they have insurance and a fund available to pay for these situations and claims. And some people might be reluctant to bring a claim against the NHS. Of course, you may well be reluctant to bring a claim. In general, they do a fantastic job under an awful lot of pressure. But if it's just an unfortunate situation, it won't cost them anything because they won't be paying out. If it's a genuine mistake, because the person is a human, they won't be paying out because they're allowed to make mistakes. It's only on those level of mistakes that shouldn't happen, that the law says is negligent, that's when they're going to be paying out. And if you are the victim of negligence, you ought to have legal redress to deal with the problems that you then have, physical problems, physical symptoms, financial losses. So the claim ought to be brought. Right, over on there slightly, I hope you don't mind. It's 3 minutes past 1 now. I don't think we've got any other outstanding questions. I'll just check. I've gone through all the questions that I prepared, so hopefully that's been useful to you all. I think the video is going to be saved and will be available to view later on by anybody else, or if you fancy watching it back again. Maybe there was something I discussed and skipped onto something else. You can always watch back, see if it answers your question again, or if you've got any other questions, or if you think you might have a potential claim, by all means get in touch with us. You're obviously on our Facebook account. You can contact us through there. The office is in Crewe. The website is just search for Step Legal Solicitors. The office number is 01270 254 064. That's 01270 254 064. If you've got any questions, get in touch, and we'll leave it there. Thank you very much for listening.